Sometimes the case cannot be dismissed because a Chapter 7 case can only be dismissed under Section 707 of the Bankruptcy Code, and that is within the context of the means test. In essence, what it says is, sorry, pal, you've got too much income to qualify for this very extreme relief of just erasing debts without paying anything at all. So the Office of the United States Trustee or some creditor, or maybe the IRS, who is a creditor frequently, may seek to have the case converted. Now, normally the case would be dismissed if your income is too high. But if your debts are not primarily consumer debts, instead they are, say, business debts or tax debts, or a few others that are not consumer debts, then the case cannot be dismissed because there is a provision in the Bankruptcy Code that says that in Chapter 7, that means test does not apply if the debts are primarily non-consumer debts. And so that's when, if it looks like you've got enough income to pay creditors something, well, they'll seek to convert the case. Now, they cannot seek to convert the case to Chapter 13 because the law is very clear. That is a violation of the 13th Amendment's protection against involuntary servitude and slavery. And to force somebody into a Chapter 13 is viewed as a form of involuntary servitude. So the other direction has been to try to get people forced into Chapter 11. Now, a very strong case can be made that the 13th Amendment's protection should apply to individual debtors being forced into Chapter 11 as well, but this has not yet been decided by any higher courts. There have been a few bankruptcy cases around the country with mixed results. Some courts have said, sorry, you can't force somebody into a Chapter 11. Others have said, well, maybe so, and they've granted such motions. I have a case now in which the judge did grant the motion, and it's being taken up on appeal. So we'll see whether the appellate court decides that the 13th Amendment really does provide my client with protection. But you may end up being forced into a Chapter 11 because the U.S. Trustee's Office was not able to get your case dismissed under Section 707 because your debts were not primarily consumer debts. So that section was off the table. So then they'll try and force you into a Chapter 11. Now, there's a little bit of cynicism, I think, on the part of the movement in this setting, and that is if they know you're not going to be successful in a Chapter 11, in essence, what they're doing is an end run around that limitation in Section 707. 707 is how you get a case dismissed in Chapter 7. That's the only way to get a case dismissed in Chapter 7. And again, I'm thinking individual cases, not business cases. So the idea is, well, we can't get the case dismissed under Section 707, so we'll force the debtor into a Chapter 11 that will be unsuccessful and the case will be dismissed. And so we do an end run around that limitation. So the debtor may have primarily non-consumer debts, can't get the case dismissed, but we'll get him into Chapter 11. He won't cooperate. The case will be dismissed anyway. We've accomplished what we wanted in 2 steps instead of 1. So I personally think that's a misuse of this whole process. And I think the conversion to Chapter 11 should only be applying, an involuntary conversion to Chapter 11 should only be applied to businesses or some kind of business entity, whether it's a partnership, a corporation, or what have you, and should not be applied in individual bankruptcy cases because of the 13th Amendment.